Okay, good afternoon, everybody. Welcome to our webinar this afternoon, where we're going to be looking at how best to handle complaints of sexual misconduct, ensure that you are complying with all your legal obligations, and also to ensure that you are protecting the well-being of those that are involved in the process. I'm going to start just by obviously introducing ourselves. I'm Lynn Marr, and for those of you that don't know me, I'm a partner in the Brodies Employment and Immigration team. So I have experience in advising a wide range of employer clients, mainly respondent clients, in handling complaints of sexual harassment or sexual misconduct. And I'm going to be joined this afternoon by Johanna, my colleague, who works, I'm going to get this wrong, but our government regulation and competition team, too many words there. Johanna is a barrister and also an associate in that team at Brodies, and she has a wealth of experience in advising particularly clients in the education sector in handling complaints of sexual misconduct, whether that be complaints from students about other students or from students about members of staff in whichever institution it happens to be. And the reason we're really doing this seminar is that when Joanna and I were experiencing our experiences of advising clients on these issues, we realised that there's a really significant overlap. And a lot of the advice that we're giving our respective clients is the same. We also realise that it's a topic which is increasingly coming up and that we are increasingly giving advice on. I think the fact that over 200 of you have signed up for today's webinar is a bit of a testament to that. So it's obviously a topic that you're either concerned about if it does arise for you, or you're currently grappling with some of the issues that we might be talking about this afternoon. We're not sure why that might be the case. It might be just simply because we are still living through the Me Too movement. But we know that there's obviously a lot of these sorts of issues arising for you. So what are we going to cover today? Well, you'll see a contents page up in front of you, hopefully, at the moment, but really how Joanna and I are proposing to deal with this is to try and take you through the journey of what happens when a complaint of sexual misconduct or sexual harassment comes into you, and follow that through really from what you do when you get the complaint through to what you might do to carry out a fair investigation, right through to how you then will go about weighing up evidence and writing up your reports, deciding whether this to be a disciplinary hearing and some of the considerations arising around disciplinary hearings, and then we'll hopefully have time to touch on some future developments before we take any questions. I should just say at the very start that we are talking, I'm coming at this very much in the context of being an employment lawyer. Joanna is coming at this very much from her perspective of advising clients in the education sector. And although, as I've said, there is a huge degree of overlap, there's not really very many differences. The one thing that we have discovered amongst ourselves is there can often be a difference in terminology. So, for example, within the education sector, a complainant is often referred to as a reporting party, whereas within the within the employment context, for all of the HR professionals that have perhaps logged into this webinar, you will be much more familiar with somebody making a complaint just simply being referred to as a complainant. So we've attempted to use neutral language and just adopted that language of complainant and respondent. And what we've also sought to do is, although we think there is a significant overlap in how you approach these types of misconduct in whether any kind of employer or whether you're an education client, we will flag to you where we think there might be any particular differences between dealing with it in the normal employment context and something that might be a little bit unique or peculiar to the education sector. So I'm going to start us off on our journey, if you want to put it that way. It sounds like I'm doing the X Factor or something. We're on a journey, and I'm going to start off really by taking a bit of a helicopter approach of just looking at some of the key pillars or overall principles that we need to really take into account when we are dealing or handling any kinds of complaint of sexual misconduct or sexual harassment. And it won't come really as any surprise to any of you to know that the fundamental one is the principle of fairness, which I know is quite a vague principle. What we will do throughout these slides is hopefully explain to you what fairness dictates in handling these sorts of complaints, but it certainly does need to be an overarching consideration. And that's really fairness to the complainant, which goes without saying. If you receive a complaint of sexual misconduct from an individual that you're responsible for, they're most likely going to be emotionally distressed and upset, and it will be quite a sensitive issue to handle, and there will be a lot of sympathy for them, and you will want to treat them in a very fair manner. But you mustn't forget about the respondent as well, because that can sometimes get lost, and we'll come back to this later on when handling these sorts of allegations. So you have to be fair in how you handle the respondent as well. And also there has to be a fairness to your wider community or your organisation. It's really important that these investigations and processes are handled fairly, so that other individuals can see that fairness happening, that they can be reassured that you do deal with these complaints, that you deal with them in a fair and even-handed manner. And that will encourage, hopefully, a reporting culture of these sorts of issues, so that you can make sure that you can prevent them, address them, and take all the necessary steps that you do to protect your reputation. And I would say, of course, as a lawyer, that one of the key reasons why you want to ensure fairness is to prevent claims materialising, and where they do materialise, to hopefully allow you to be in a position that you can successfully defend them. And certainly in the employment context, fairness is obviously a key principle. You want to make sure that you are carrying out a fair and reasonable investigation and a fair and reasonable disciplinary hearing. And if you do that, you're going to be much more likely to put yourself into a position where you can stop further grievances arising, which of course is time consuming for everyone and reputationally damaging. You don't want complaints about the procedure that you followed. And certainly it should also allow you to stop claims of things like unfair dismissal, constructive unfair dismissal, or further discrimination complaints materialising at all, as I say, you being able to successfully defend them if they do. The other key pillar that I'm going to touch on is policy and procedure. We all love a policy and procedure, but they are really important. Organisations should have a policy in place which will allow them to adequately respond to allegations of sexual misconduct if they are received from somebody that they are responsible for. And of course, for employers, that might be to invoke either a grievance policy, a dignity at work policy, or a bullying and harassment policy, or you might indeed have a standalone sexual harassment policy. But the reason they are so important, and people I think forget this, is that when they are drafted, and I'm thinking about HR professionals drafting these policies, they're not just drafting them to have them put on a shelf. They're drafting them with a view to making sure that the procedure followed complies with all the principles of fairness that we know from case law and legislation are the key elements of ensuring a fair and reasonable process. So in other words, if you follow your policy and procedure, you can't go far wrong. You would like to hope that if you do that, then you will be able to establish fairness. That's not to say that you should follow policies and procedures slavishly. It will sometimes be necessary to depart from them, but following them generally will avoid any arguments that you've acted inconsistently and that you're treating somebody differently, and that in itself might amount to discrimination. And it generally keeps people right who are involved in the process. So if you have a policy or procedure, keep it in mind, get it down and follow it, unless there are particular reasons that you're not going to follow it. And if there are, then it's a good idea to document or get agreement from the parties involved as to the process or procedure you're following instead, and why you are departing from it. Okay, so that's our kind of overall principles or key pillars. What should we do if we do receive a complaint? What are the initial considerations? Well, the first thing, of course, when it comes in is that you're going to want to act fairly, and you want to be able to respond quickly. These sorts of allegations, because they tend to be of a very serious nature, they will exercise a lot of people in your organisation, and you will want to respond very quickly. I think time and time again, and Johanna might nod if she agrees with this, but when these sorts of complaints come in, there can be a bit of a temptation just to jump in a bit quickly with 2 feet, because you're more concerned with signalling to the parties that are involved that you're treating this really seriously and you're on it and you're going to deal with it quickly. And that can really backfire. I've certainly had a client who received a complaint of a very serious allegation of sexual assault. They were so keen to kind of deal with it that they immediately started reaching out to all the potential witnesses, taking initial statements from them without setting up issues around confidentiality between them all, and without understanding whether the complainant wanted to go to the police or had in fact gone to the police. So it really, I would really caution against doing that, no matter how much you want to be able to reassure the parties that you're dealing with it quickly. I would say take time to step back and make sure that you really do plan the approach. I mean, that's the same really for any kind of investigation into any kind of misconduct. But I would say it was particularly the case with allegations of sexual misconduct, because they do differ. There are some things which come up in the context of a sexual misconduct investigation or disciplinary process that don't arise so often in other kinds of misconduct cases. So, I mean, I've put on the slide the sorts of things that you might want to think about in preparing a plan for your investigation, but thinking about what exactly is complained of, what policy or procedure is engaged. For example, can the matter be dealt with informally? And I'm thinking about in the employment context where that is a possibility. You might be able to, depending on the seriousness of the allegation, but you don't want to have to do a formal investigation if you can possibly avoid it. Do the allegations involve any sort of criminality, and does that impact your initial response? We'll come back to that because we are going to talk a little bit about police involvement. Think very carefully about who it is that's going to investigate. Are there any sensitivities around that? And what are going to be the timescales for completing the investigation? How are you going to communicate with the people that are involved? How are they going to be updated? How are they going to be supported? And then maybe not before you start communicating with the parties, but certainly you need to think carefully about what facts need to be established. What sources of evidence might there be? What evidence do you need to gather, or your investigating officer, what do they need to gather? Which witnesses do you need to speak to? And then actually think about, I mean, this is really the job of the investigating officer, but you're going to have to think carefully about what the lines of questioning are, and think carefully about whether they're appropriate. And there might be issues around that in a sexual misconduct case about the questions that are being asked. And of course, the investigating officer might need some support with that. So don't jump in too quickly. Do take, a day or two to plan. I mean, you can still do this all quite quickly, but you do need to take a bit of time just to step back and get your plan of action. So what I'm going to then just do now in the next part of our journey really is to pull out, I think, some of these issues that might just have a little bit of a difference when you're dealing with a sexual misconduct complaint. And the first of those is around appointing the investigator in the first place. Now, of course, this is going to be a bit of a consideration in any kind of investigation that you're doing. But in the context of sexual misconduct complaints, there are a few things I would say. And the first is that certainly in the employment context, and I think this is true of the education context as well, it might well be that you want to go externally and find an external investigator. And that's often out of a desire to make sure that the investigation is completely impartial, that it's done independently. It might sometimes be appropriate because an allegation is made against somebody who is very senior, and there's not really anybody in the organisation who would have the genuine authority to make findings against that person. So it might be appropriate to go external for all sorts of reasons. The other reason you might want to go externally is just because you just don't have anybody internally who is suitably trained to deal with sexual misconduct cases. And it is recommended that whoever is investigating such cases has had some training in these sorts of issues. I think for the majority of our employer clients, we would say, don't go external. As far as you possibly can, use somebody internally, because they will know your organisation as well. And of course, you may have to make sure that the other considerations about appointing an investigator are met. So you do want to ensure that the clean hands rule is met. So the investigator should not be somebody who's had any prior involvement in the issues that are complained about. And they shouldn't really have, it goes without saying, any personal axe to grind against either of the parties involved in the complaint. So you need to make sure that the clean hands rule is engaged. And we've obviously seen some very high profile cases involving politicians where that was one of the key issues, that unfortunately there had been prior involvement by the poor investigating officer before she was asked to investigate particular complaints. They must also have adequate authority to carry out the investigation as well. There's no point in giving an investigation to somebody who feels that they are going to have their ability hampered or interfered with at every turn by more senior people in the organisation, or by people, for example, within the HR function. And they must be properly resourced. You think about, if you're going to appoint somebody as an investigator, make sure they're not just about to go off on a period of parental leave or an extended holiday, or they're about to be embark on some work project which is going to take up all their time, so they're just not going to have time to devote to this. Make sure that you've sorted that out at the outset, because it can derail or at least delay the start of your investigation if you have to start over on the process of finding an appropriate investigator. And also making sure that they have appropriate support. That might be access to in-house lawyers, obviously HR professionals in the employment context, but they might also need some help in recovering documents from engaging the assistance of things like their IT function. If you need to recover emails or messages, Teams messages, all that sort of stuff. So make sure that all that support is available to them. Particularly on the HR front, employers, Joanna and I were talking about this yesterday, that larger employers with large HR functions get a really rough time in the employment tribunal. If you've got a large employer who has a dedicated HR function, you're pretty much expected to take HR advice. So making sure that all that support is available is pretty critical. And the next point that often comes out, again, in the context particularly of sexual misconduct complaints, is around precautionary action. Now, again, for the HR professionals on the call, I'm thinking about suspension, but in the education sector, I know that that's largely called precautionary action, but we're really talking about the same thing here. And so you might be thinking about excluding or doing something to remove from the situation the respondent to the complaint whilst the investigation is ongoing. And that can be necessary in order to protect the witnesses. It could be necessary to protect the respondent themselves from further allegations of misconduct while the investigation is ongoing. And it's just there sometimes to avoid the investigation being interfered with. So maybe collusion between witnesses or the respondent, I don't know, trying to delete messages or something like that. You might need to remove them from the situation. But we're all very clear, and I think it goes without saying, that precautionary action is never used as a sanction. And so you would be making it very clear to the respondent, if it's them that are suspended, that it is a precautionary measure only. It is not intended to indicate any prejudgment of the process or the potential outcome. And hopefully that will reassure them. I mean, I'm sure you will imagine that saying that it's a precautionary measure doesn't always reassure many respondents. And as we'll come on to, I'm going to talk separately about suspension in the employment context. But obviously, if you are going to do this, you need to do a comprehensive risk assessment to really genuinely work out whether you think that precautionary action is in fact necessary, or is there some alternative that would actually achieve the same aim. And of course, any suspension or precautionary action should be kept to a minimum. So you should try and only suspend somebody or have them excluded for the minimum amount of time possible. And obviously, you should keep it under review and keep that individual updated as you progress with your investigation. So I'm going to talk just a little bit about suspension, particularly in the workplace, because what I certainly find is that often where serious allegations are made, employers often very, very quickly move towards suspension. And I think that's based on these very historic notions that employment tribunals will criticise you if you don't immediately suspend where there is something that might amount to gross misconduct. We have kind of moved on to that, moved on from that, and a lot of you will be familiar with a lot of the case law, which makes it very clear that suspension should not be a knee-jerk reaction. So it's usually going to be a good idea to do a little bit of initial investigation before moving to suspension. And that will include speaking to the person that has been accused of the misconduct or the harassment in the workplace. And you do want to think very carefully about whether there are alternatives. So don't just suspend a respondent because mud sticks and they're going to be concerned that their reputation is going to be damaged, and that you might call this a precautionary measure, but it's not a neutral term. They will feel that if they're removed from the workplace, that there will be some longer term damage to them. So think about whether it is possible to request both the complainant and the respondent to work in different locations or from home. Maybe think about adjusting their working hours so they're not going to come into contact with one another, adjusting their supervision hours. In the education context, you might request avoidance of particular areas by the respondents, for example, student halls or the library. So there are various things you can do. Ultimately, you might decide that it is necessary to suspend, but if you do, being able to show that you've gone through that thought process and you've documented it is going to be really helpful. And again, in the employment context, I would just caution that the default to thinking, oh God, we better not suspend, is don't just move the complainant, because that is really running the risk of them feeling that they have been subjected to some sort of double unfavourable treatment. You know, not only do they feel that they have been subjected to sexual misconduct or harassment, but now they're being punished by them being moved. So watch out for that, because you don't want to then end up with a victimisation complaint as well. Now, I said we would touch on police involvement. And this is something which does arise very much in the context of sexual misconduct, because wherever there are allegations of sexual wrongdoing, there is a high chance there's going to be some criminality as well. The definition of sexual assault in Scotland is very, very broad, so it does often arise. There will be some circumstances, and Joanna and I are thinking predominantly of the school type setting, where there will be a policy, or there will be certainly a practice where allegations are made of sexual misconduct, where you're just going to go automatically to the police. And that's generally because those allegations might involve children or young vulnerable people, and you will have to report to the police or the social care services. But in the employment context, in the higher education context, that's much rarer. You will not, as an employer, generally be reporting matters to the police at all. And if you do have a policy that covers any police involvement, it's much more likely to say, please be reminded that if you make allegations of sexual misconduct, they might also constitute criminality, and you're absolutely entitled to go to the police, notwithstanding the fact that you are raising it with us as your employer. And certainly if you've got a sexual offences officer, I don't know if that's quite the right term, Joanna, in the education sector, and in employers maybe appointing HR professionals or others, workplace type champions, to support somebody making a complaint, you will probably be saying to them, have you spoken to the police? If they haven't, you'll be reminding them of their right to do that, not just then, but at any stage in the procedure. And if they have raised it with the police, that might impact what you do, because it might well be that you get the crime number, you speak to the police, and actually you don't embark on the investigation immediately. But that is going to be very dependent on the circumstances. So it's useful to take advice on that as it happens. There's no hard and fast rules about what will happen if the police are involved. We tend to find very often that the police will say, don't investigate, particularly if it's a serious allegation, because they want to carry out their investigation. And it's probably not sensible for you to do that, because the police will ask for whatever you've done, and that can cause issues as well. But it might well be that once the police have gotten so far through their investigation, they will come back to you and say, fine, we're happy that we've preserved evidence that we need to preserve to deal with any potential prosecution or reporting this to the Procurator Fiscal, so you can get on with your investigation now. And of course, that doesn't mean that the criminal proceedings will have concluded, so you might be doing your bit whilst criminal proceedings are ongoing, but there's nothing to prevent you necessarily from doing that. Okay, drafting and screening allegations. I think this is probably, it is important both as an employer and in the education sector, but I think it's probably a little more detail is probably required, I think. I'm sort of looking at Joanna when you're drafting these allegations in the education sector, but it is really important, obviously, in the employment context, to make sure that when you're getting an allegation, particularly if it's going to be something that amounts to gross misconduct, that you're able to frame it as precisely as you can, because it's really important that the respondent in any context is put on fair notice as to what it is that they are actually being investigated for, and so that they have an opportunity to be able to respond appropriately to the allegations that are being made. One of the things that arises very commonly in the employment context, but I'm sure it also does in the education context, is handling historic allegations and the extent to which you have to do that. I know there's always a bit of a tendency to think, oh my God, how are we going to investigate this? People have left, memories have faded, this is ridiculous, can't we put some sort of time limit on it? I would certainly caution against that. You don't know what you're going to find until you start investigating. And if you don't actually investigate those historic allegations, you might find that the employee makes a subsequent complaint that you failed to give them right of redress against grievances. They might bring further discrimination complaints. And not great if a failure to look at the historic complaints is done, but then there are subsequent or fresher allegations that come to light. So it could be reputationally damaging to ignore historic allegations as well. And I think the best thing to do is really just to try and investigate them. It might be difficult, and it might well be that quite quickly you realise into the investigation that there's just not any evidence that you're going to be able to uncover to help you establish that they are well founded. And of course, all parties to the investigation should be directed to maintain confidentiality, and we're going to come back to that in some later slides as well. So if we are continuing on in our journey, we're getting into the investigation process now. Obviously, that has to be fair, and it has to be seen to be fair as well. So this is going to involve thinking about fairness again, and how you are dealing with those that are going to be involved in the process, particularly the claimant and the respondent. And you want to really make sure, and I know this sounds very trite, but it doesn't always happen, that you are handling the respondent and the complainant in a very even-handed manner. If you were looking at this externally and you were looking at the questions that were being asked and the tone that was being used, would you get that even-handedness? Would you see that questions were being put in a neutral way? Is the correspondence neutral? Is it very factual? Because there can be a tendency for there to be a bit of an imbalance, a lot of sympathy for the complainant who might be very emotionally distressed versus the respondent who can sometimes, unfortunately, be left a little bit out in the cold. So do remember about the support for them as well. I mean, obviously you'll have to consider support for the complainant, and often you'll have either workplace champions or people that will support those bringing complaints of sexual misconduct. They might have access to employee assistance type helplines, or they might have access to some sort of form of counselling to help them. But think about the respondent and what they might need as well. And certainly fairness to them is knowing what the elements of the allegation are and knowing them early as well, so that they have an opportunity to consider them and to respond to them and they don't feel left out in the cold. And of course, it's preferable if the key elements of both the complainant's and the respondent's accounts are put to one another, particularly if there's going to be an adverse finding in relation to credibility or reliability to be made. Some witness issues that arise, reluctant or vulnerable witnesses. Again, this comes up quite commonly, I think probably in both areas, particularly I come across it in the employment context, where you get that typical scenario where somebody comes to usually the HR function, they say, I want to make a complaint about X, but I don't want you to do anything about it. I just want you to know about it. I'm not asking you to do anything about it. And that presents a real problem because you've maybe been put on notice of something pretty serious, but how can you investigate it if the complainant doesn't want you to take matters any further forward? That is a really tricky one. And there are certainly risks associated with just saying, okay, well, we can't investigate because you don't want us to. And the risks are things like, well, there might be further harassment of others and you've suddenly got other complaints or other claims. It might be reputationally damaging for you not to investigate it. It might be so serious that you really feel that you have to do something about it. I think there are some things that you can do to try and persuade the complainant who is reluctant to actually be involved and to engage in the process. You can make sure that they understand that some degree of confidentiality will be there during the process, that you will support them and try to encourage them to allow you to take it forward. But if they really, really won't let you, I think it would be good advice to record that in some way and make sure that they see that you've recorded that. So correspond to them and say, you've made this complaint, you don't want to take it forward. We've discussed with you the sort of support that we could offer to help you do this. We would really like to investigate it, but you've confirmed that you don't want us to. And then maybe check in with them from time to time, find out how things are going. Have things changed? Have they changed their mind? And that will hopefully at least be able to allow you to be able to demonstrate that you did try to provide support and that you did try to investigate matters as fairly as you could. And we also come up against requests for anonymity as well. Again, another problem, it's really, really difficult. And again, high profile cases that you will have seen, this is the sort of issue that is created. You can't keep from a respondent the allegations or who's made the allegations because it prevents them from being able to properly respond to them. So it'll be very rare to be able to grant requests for anonymity unless there really is some real concern about a fear of some sort of physical recrimination or something like that. So it comes up quite regularly, but it's very difficult to promise anonymity to people that are making complaints. And then I think the last issue that I'm going to deal with before handing over to Johanna, who's been waiting very patiently, is some questioning do's and don'ts. Obviously, when you are preparing questions in this sort of context, it is a little bit different probably from how you might do it with other kinds of misconduct, because you're going to have to be very sympathetic and non-judgmental. You don't want to give a sense to either the parties, particularly the claimant, that you believe them and you believe what they're saying, and that you believe everything that they're saying is accurate. You don't know that until you've completed your factual inquiry. So, try not to let your emotions get the better of you in terms of your sympathy towards somebody who might be quite emotionally distressed. You have to try and stay as neutral as you possibly can. listen to the answer that you're given in response to the questions that you've prepared in advance, and obviously be adaptable, because you're going to have to be able to listen to the answers to the questions that you have posed, and consider whether or not the witness is actually answering it. I think one of the things that we typically see when we see minutes of meetings is you see a line of questioning, you think this is good, this is good, this is good, and then you suddenly it just drops, it goes nowhere, and you think, oh, I just wish they had asked this follow-up question. I think a good way of thinking about it is to ask the question, listen to the answer, and then question the answer. Is there something that you need to ask them more about? Have they been a bit evasive? Have they not been consistent with something that they've said earlier that's not consistent with a document or something that you've seen? So you have to be, you can't just go through a list of pre-prepared questions. You do really have to be quite adaptable and follow up on the answers that you get. You need to be able to test credibility and reliability, which is going to be really important to the investigating officer when they come to write the report. And that's because often in these cases, you might not have a lot of witnesses so that you're not getting a lot of direct witness evidence, and there might not be a lot of other direct evidence, such as CCTV footage. You might not have minutes of, you might not have things like emails or sort of Teams messages or social media type correspondence. That might just not be available, and it might just be one person's word against another. So you probably are going to have to make an assessment of credibility and reliability, and that means you've got to really watch the witnesses, the complainant, the respondent, any other witnesses, whilst you are questioning them. And obviously if they're upset or uncomfortable, you don't want particularly the claimant to be further traumatized. So, do take breaks, but watch them. Are they being evasive? What's their body language like? Are you getting a sense from them that they're maybe not giving you the whole story? Do you offer the right to be accompanied, at least to the claimant and the respondent? Particularly in the employment context, there's obviously a statutory right to be accompanied by at least a trade union rep or a colleague. That can be difficult because sometimes people don't want colleagues to come. They feel like they might be putting them into a difficult position. They might not be union reps. So I think particularly where there are allegations of sexual misconduct, do think about whether you need to stick to the strict letter of policies about only allowing trade union reps or colleagues to come along. And don't offer blanket confidentiality to witnesses. Again, it's a common thing that we see, particularly in these sorts of cases. People can be reluctant to speak out against maybe managers or more senior people. They think it might have an impact on their own career prospects or them in the workplace. And so they'll say, well, do it, I'll speak to you, but only if you guarantee me some sort of confidentiality. You can't really do that. I mean, what you will say to witnesses is, we expect you to keep what you've told us confidential whilst this process is ongoing, but there might come a point where their evidence or their witness statement has to be disclosed, particularly in disciplinary proceedings where a respondent is going to have to be able to answer to the allegations. And at that, I'm going to hand over to Johanna and put myself on mute.
Thank you very much, Lynn. That was a really clear run through from start to finish, covering some of those principles and those initial key steps that need to be taken in order to make sure that the outcome is fair, that thread of fairness runs all the way through. So we're at the point here where we are weighing the evidence and writing our report. So if we can just move on to the next slide. The first point that we make there is about maintaining the evidence. So as Lynn mentioned, it may be a one-off event where there really isn't very much evidence. But on the other hand, and we have very recent experience of this, there may be multiple allegations over quite a prolonged period of time. So actually maintaining that documentary evidence, you may have video footage, you may have WhatsApp messages, you may have Snapchat, you may have a whole range of evidence in front of you. And it's coming at you on a sort of piecemeal basis. So you really want to maintain that evidence in a PDF bundle. And that's going to make the writing of your report following on from that so much easier, because you'll be able to refer to page numbers, and there's no reason why you shouldn't do that. So your structure when you come to writing your report is absolutely key. As Lynn mentioned, certainly in an education context, you may have quite drafted fairly detailed allegations, and just following through those allegations in your report is a very useful way of doing it, including referring to your misconduct or your harassment policy. And we've set out there a suggested approach. So how should you structure your report? How should you write it? So of course, you're going to have an introduction, and that's going to detail the breach of the policy, the breach of the code in question. You're then, we would suggest, going to explain how you approached the investigation. So who did you interview? When did you interview them? Were they accompanied? Narrating all of that. You then, the next step is to set out what are the details of the allegations of misconduct in front of you. And as I said, they may be fairly short. It may be one incident, but they may be, there may be multiple allegations. They may be very detailed. And certainly in a recent case where I acted as a conduct investigator, that was exactly what we had. So over 280 pages of evidence, multiple allegations. And the way that I approached it on that occasion was to group it into certain incidents. So and breaking down the allegation in that way for clarity and structure in the report. So you might head an incident something like the Christmas party incident, the training away day incident, and you would then go through summarising the evidence. Now, again, what we've said there is there isn't a need to rehearse every factual account of every witness that you've spoken to. As Lynn said, you may just have interviewed the complainant and the respondent, or the complainant may have brought along witnesses that he or she spoke to after events, which they say corroborates their version of events, for example. But the key point here is you don't have to rehearse that line by line. Again, with your evidence bundle, you might have a second appendix that's got all of the witness evidence set out there. But what you do need to be careful about is paraphrasing. So where you're rehearsing those factual accounts, just be very careful that what you are saying does align directly with the statements that you've taken. So just to go back to my point about, grouping incidents, what you might then do is say, deal with, when you're summarising the evidence, you'd be dealing with, say, the training away day incident, and you would set out, Mr. A said this is what happened. You would then set out all of that evidence. You then use the same heading, training away day incident, Miss B said all of this happened. So in that way, you're rehearsing and properly summarising with page references to your bundle all of the evidence that's in front of you. You then get onto the key part, which is how do I assess that evidence? How do I interpret that evidence? And again, you might just want to set out there the key test that you're applying. So did the misconduct take place? Was there a breach of X policy or X section of the code of misconduct? And again, another really helpful way of approaching this critical, and it's important to say this is a critical part of the report, is to say what is not in dispute. So set out what the parties are agreed on. There was a meeting on X date. There was X person in attendance, and you narrate all of that, because what that then allows you to do is set out what is in dispute. So it's really just trying to narrow down again and again the critical and key issues that are before you for your assessment and for you to come to a conclusion on. And as Lynn's already mentioned, you are continually assessing the credibility and the reliability of the witnesses and the evidence before you. And what that then should lead to are key findings of fact. You've got to make those key findings of fact, and they are then going to provide the basis for your reasons as to your final decision. And I think what we also mention in the slide there is that your report should be clear throughout what legal test you are applying. So what is the test that's being applied here? And usually it is the balance of probabilities. And just to explain that a little more clearly, I hope, on the next slide, what we've set out there, again, it's just a suggested form of words. And of course, each investigation in each case may merit something slightly different. But one good way of sort of rounding all of that up is to say something like, based on the evidence before me, on the balance of probabilities, I do not find that Mr. A touched Miss B on the leg on X date. So you're being very clear in the run up to the conclusions of your report, what your findings are. So if we just move on from that, so where might we end up from here at a disciplinary hearing? And again, what are the key considerations? Fairness is absolutely central to any disciplinary hearing. And it goes without saying that the more serious the allegation, the more serious the consequences. It may lead to an exclusion or a career-ending moment, then the greater the expectation will be for fair procedure. So another critical point is to think about what's actually being decided. What is the alleged misconduct? Is everybody clear that's at that disciplinary hearing what is being decided? So just by way of example, last week we were involved in a disciplinary hearing, but in that case, not all of the allegations of misconduct were found to have been proven. So in fact, what was in front of the disciplinary hearing was an element of the allegations, but not all of the allegations. So it's really important that the parties know what's being decided by that disciplinary committee or by that disciplinary decision maker. And again, policy is crucial. That should be giving you the detailed guidance on the procedure to be followed. If you're in any doubt about how the policy should work in practice, then it's always really good idea to get advice before you are there on the day with a question as to how things are actually going to operate in practice. And again, you know, point that Lynn's touched on earlier, care needs to be taken in relation to the possibility of a risk of re-traumatization. Again, appreciating that in an employment context, the complainant, it may well be all being dealt with through evidence and through the papers in front of the disciplinary decision maker, but in an education context, the complainant may or may not have agreed to want to give evidence, but if they have, then again, training of the committee will be key in terms of relevant and appropriate questions that are being asked. So if we go on to, again, think about some of the more detailed matters that need to be considered, and I think I just touched on this issue of training. Training is absolutely critical. So how are those that are responsible for conducting disciplinary hearings in sexual misconduct cases, how are they being trained? Have they been trained? And how are they being advised and supported at the hearing? Is that person confident around the policy, how it applies, what is and isn't an appropriate question, what's relevant, what is it that's being decided, who can and can't ask questions, and so on. And that's the sort of question that arises in our second bullet point. So the complainant's evidence, how will it be put in front of the hearing or the disciplinary decision maker? Will there be any witnesses that the complainant has relied upon? Will they be there? Will they be corroborating the case of the complainant? And if they're not, is it done through the documentation? Does it just come out through that hearing process? And again, appreciate that in an employment context, this may be less relevant, but will cross-examination be permitted? Again, in our case that we were dealing with last week, this was a key point, a preliminary point, in fact, that was taken by senior counsel who was representing the respondent, stating that they wanted the right to cross-examine the complainant. They weren't allowed to cross-examine the complainant, but if you're not going to allow that, you then need to think very carefully about how the positions and the versions of events of the complainant and the respondent are put to the other party. So absolutely crucial that the evidence is tested. And if it's not going to be tested through the usual sort of processes of cross-examination, then it's even more burden falls on the disciplinary decision maker or the committee to make sure that the evidence is tested. And the final point, again, that Lynn's touched on earlier on, is who can accompany a respondent. What if a respondent wants to bring along a lawyer? In fact, another case, just touching on Lynn's point about police involvement. In fact, I attended as a legal advisor to a committee where the respondent student had been the subject of a criminal investigation and had been convicted for sexual offences, spent time in prison, was then back in front of the university's SDC, and that's the Student Disciplinary Committee, defending his position about not wanting to be excluded from the university, and again was represented by senior counsel. So in an education context, it seems to be becoming more and more usual for lawyers to be brought along. And we're really just flagging the point there that in employment, though it's not usual, there may be exceptional circumstances that might allow that. So if we move on to our next slide, so what happens once the decision has been made by the disciplinary decision maker or by the committee that's looking into the sexual misconduct? Where an allegation of sexual misconduct is held, it may be that the employee or the student accused is not dismissed or excluded, and therefore questions will arise about what can be done to make sure that people can move forward and continue to work and study in the same organisation. Is there any follow-up support that's required? Are there lessons to be learned about the process? And again, that question of training might come up at that point. Is there wider equality or misconduct training that's needed? And even if the employer or the student accused of sexual misconduct is dismissed or excluded, there may still be considerations about support for the complainant or perhaps their witnesses, others that have been involved in the process in terms of supporting them. And again, if that complaint is not upheld, how is that going to be communicated to the complainant, and how are those future relationships managed? So they're just some of the things that need to be considered when we're looking at the outcome and some of the consequences that flow from that. So if we move on to the final section of our presentation to you today, which is about some developments and further considerations in both the employment and education context. And I'm going to hand over to Lynn, first of all, just to touch on some of the things that are happening in an employment context.
Thanks, Johanna. Yeah, so there's obviously been a wealth of activity by the government. There have been loads of consultations that have been happening over the last couple of years. Them having been embarked upon, there was quite a period where we really heard nothing very much back and everybody wondered what was happening to them. But this year we have obviously had the response in around August this year. We got the response to the government consultation on sexual harassment in the workplace. And so what we do know is that when parliamentary time allows, and I'm not sure quite when that will be, but there is to be introduced or there is proposed to be a mandatory duty on employers to prevent sexual harassment in the workplace. So that's something to look out for in terms of working out exactly what it is that you will need to do to comply with that duty. And we're also going to probably see the reintroduction of an obligation to protect employees from third-party harassment. Many of you will remember that we previously had that and that was repealed, but there looks to be some reintroduction of that. And there's also a commitment to looking at extending time limits for complainants wanting to bring sexual harassment complaints in recognition of the fact that obviously after these sorts of events, it can take people quite some time to really get their head around even thinking about bringing a complaint. And also there's going to be a proposed EHRC statutory code of practice and guidance for employers. And that's really going to follow on from the technical guidance that was actually issued in January this year. And that will hopefully begin to help employers better understand exactly what it is they need to be doing to establish the reasonable steps defence. So if a claim is brought against them, there might be a better opportunity for them to argue that they have done everything they possibly could to prevent harassment from arising in the workplace and that they have taken steps to address it when it does.
Thanks, Lynn. And just to give some of the recent developments in the education context, you'll see there we're just flagging the rapid review, I think it was called, of sexual abuse in schools and colleges that was undertaken in England by Ofsted, and that was in response to the Everyone's Invited website, which I'm sure many of you will be aware of, which hosts, I think, now over 54,000 testimonials of sexual abuse in schools and in universities. That rapid review by Ofsted then led to the Department of Education publishing statutory guidance, very detailed guidance for schools and colleges on safeguarding children. And of course, in Scotland, we've had a refresh of the national guidance for child protection, as I've said there, on the 2nd of September of 2021. And again, recent calls by the independent regulator for students in England for universities and colleges to review their policies. So it remains very much an area at the forefront of challenges in education. and indeed where those processes are not considered fair, it's certainly not unusual, and we've had very recent case law last year about the right to legal representation, for example, in front of a university disciplinary committee. So if you don't get the process right, it is not unusual to be challenged by way of judicial review. So we're just going to end on some further considerations, and this applies to both employment and education. And we've just flagged there the question of, is a culture review necessary in your organisation to identify any systemic issues? Is your policy and procedure effective? Is it fit for purpose? How is monitoring being undertaken of complaints in your organisation? Are there any barriers to reporting? Are there effective reporting mechanisms? And is what you see going on within your organisation consistent with its stated values? Big question around confidentiality that Lynn's already touched upon. Can it be guaranteed? Should it be? And specialist training. Again, we hope that you take that away from today's session. Is it needed in terms of both the investigations and the disciplinary hearing itself? And then just a final point there in relation to record keeping, absolutely key. Is your organisation's record keeping robust enough? And I think, Lynn, that leaves us with 5 minutes, which incredibly, we were very worried about how much we had to get through and getting to this point. But we do have time for some questions. And there's a question here about what is the status of a complaint case if the police are conducting an investigation and employer investigation can't go ahead? I think this is a question actually, Lynn, that applies in both contexts, but would you like to answer that just from an employment perspective?
Yeah, it is a very tricky one, because I suspect that the scenario that the questioner is thinking about is where there has obviously been something that's quite serious that's happened. There's an allegation of criminality. The employee might well have been charged, or not. There's maybe an investigation ongoing. The police have presumably told the employer that they don't want them to investigate because they're concerned that that might in some way prejudice the police investigation. I think what that really means for the employer is, obviously you don't want to go against a request from the police not to investigate. As a matter of fairness in the employment context, it's going to be really hard to secure a dismissal if you went ahead to dismiss that employee without carrying out your own investigation. So it does kind of tie your hands, and you might just be in a position, and this happens quite often, where the employee is in fact suspended. So they're not attending work because you're wanting to keep them away, given probably what's a very serious allegation that might indeed make them inherently unsuitable at some point in the future to be able to do their job. So it can quite often lead to employees literally sitting at home on suspension and being paid, which is really unsatisfactory. Or of course, you could take a bit of a risk-based approach and just go ahead and dismiss. If the allegation is very serious. Yeah. I wouldn't say that's a bit of without taking advice, because it's a bit of a nuclear option. But if the police investigation is going on for a very long time and there are particular set of circumstances where you don't want the employee to be in your organisation, you might decide to take a risk-based approach and do that. Yes, yeah.
And there's a second question, Lynn, for you in relation to time limits for submitting a complaint relating to sexual harassment.
Yeah, okay.
An extension of time. Yeah.
Yeah, so at the moment, you've got 3 months from the last act of harassment. So if it's a one-off act, you've got 3 months from the alleged act of harassment. But of course, there might have been a course of conduct, so in which case you'd be looking at the last act. What is being proposed, or what seems to be being discussed throughout the consultation, is extending that to 6 months. So it's essentially doubling the time limit, which would take it out of kilter with other kinds of employment-related claims where the time limits are generally 3 months.
Great. Well, I don't think we have any additional questions over and above the ones that we have, but if anyone has any thoughts following the webinar, please don't hesitate to get in touch with either Lynn or myself. Our details are on the slide in front of you, and of course we can be contacted through the usual email method. But but I think it just remains to us to thank you all for attending today. We'll return 5 minutes of your time to you, and we would just ask if you could please fill in the feedback, which I think will come up once the webinar ends. It's just 5 very short questions, takes less than a minute, and helps us shape the future webinar program to what you would like to hear about from Brodies. So thank you all very much for your time today.